In this session, we will see about the misrepresentation in the prospectus. Prospectus is a document issued by the public limited company to the general public inviting application for purchase of shares or debentures. This general public is investing money in the company only based on the information in the document prospectus. For example, a person in Chennai may not be knowing a company in the Delhi or Ahmedabad, but he will be investing money only based on the document. So the document should give the true picture of the company. What is to be stated should have been stated. There should not be any omission of information. The Companies Act also, it says that these are the details to be given, and it asks the people to, in the company management people, to state out all the things in the prospectus. So in case if there is a misinformation, if the information is not correct, untrue statements are given in the prospectus, the effect will be the people will be losing their money. We will see what will happen if there is a misrepresentation in the prospectus. First remedy is damages for deceit. That the other people have deceived me. I lost my money, so give me the damages. First choice, damages for the deceit. You have to prove that there was a fraudulent statement and you say that I lost my money. One case, it's a very old case, Derry versus Peak. In this case, the company was running trams by use of horses. Subsequently, they got the government permission for use of steam. But they were to get one more permission from Board of Trade. They thought once the government gives the permission and the other will come. They issued a prospectus. They stated that we have got the government permission to run the tram with steam power. People invested money, but the Board of Trade did not give permission. The company could not use steam as a power for their trams. Company lost its money. People filed a suit against the directors. But it was held like that the directors were not liable. Reason: if it is to be proved as a fraud, what are the essential things for a fraud? The statement should be untrue statement. The person making a statement should know that it is untrue. The person making a statement should have the intention to deceive the party. So in this case, that it is untrue statement, but they were thinking that the Board of Trade will also give permission. They don't know that this is untrue. There was no intention to deceive the parties. No intention to deceive the share. They were thinking that in good faith they thought that other permission will also come. That is why. So it is not a fraud. There is another case, Edgington versus Fitzmaurice. In this case, they were issuing shares. In the prospectus, they reported that we are going to go for this expansion, all these things. Actually, the money was for paying their loans. It was held it is a fraud. One condition for this, for claiming the fraud, damages for fraud, the people should have purchased the shares only based on the prospectus. If you are buying a share in the share market and then claiming that there was a fraudulent statement in the prospectus, the person cannot claim. He should buy only from the company based on the prospectus. Peak versus Gurney was a case where 2000 shares were issued. The person purchased the prospectus, but he did not invest at that time. Subsequently, he purchased from the outside secondary market. It was held you cannot claim damages based on the prospectus. The company will be liable for the acts of the director. If the directors had made a fraudulent statement, company is also liable. In that case, Andrew versus Markford, they issued a shares, issued a prospectus. There was no application for the purchase of shares. What they did, they fraudulently, they published a telegram based on the telegram information many people purchased. It was held the company is also liable because the directors are acting as an agent of the company. You are also liable. Company was held as a liable for the damages. This is the first one. Damages for the deceit. For the fraudulent activity of the person, directors or the company, they have to pay damages. Second is compensation under section 35. Section 35 of the Companies Act provides for compensation by the shareholders. When the Terry versus Peak, already we have seen that is the directors were not liable because they made a statement which they believed it to be true. At that time in England there were many protests because that decision is not protecting the shareholders. Subsequently they passed a act called the Directors Liability Act in 1890. And in section 43 of the English Companies Act 1946 that was incorporated. In our Indian Contract Act also it is incorporated as section 35. The directors will be liable for the compensation can be claimed from the directors. Who will be liable? Number one, the directors. Number two, who has authorized the company to use his name as a director? Number two. Number three, promoters. Number four, anybody who has authorized the document, who has authorized the prospectus, such as the secretary or any other person who has authorized the document. These four people will be liable for compensations under section 35. Directors, anybody who gave the permission to be used his name as a director, promoters and the person who has done it. Then what are the defenses available to this person to escape liability? These persons can escape their liability under section 35 if they have withdrawn the consent before publishing, or they have published their withdrawal if it is after that, or the prospectus was issued without their knowledge, or if they believed that it is the true statement, they were having reasonable ground to believe that it is a true statement. Number four, they don't know if the prospectus has such a wrong statement or the statement is supported by the expert. These are the 5 instances where the directors can escape liability. Number 1, withdrawal of consent. Number 2, prospectus issued without their consent, without their knowledge. Number 3, ignorance of such statement. They don't know that prospectus is having such a statement. Number 4, they had a reasonable ground to believe that it is a correct statement. Number 5, the statement is supported by the expert opinion. These are the 5 conditions. So we have seen damages for deceit. Second, compensation under section 35. Next is a rescission for misrepresentation. If there is a misrepresentation, the person can have the right to rescind the contract. According to the Indian Contract Act 75, he can get back his money. He can rescind the contract. So here what is the contract? A contract is to purchaser. They can rescind the contract if there is a misrepresentation. For example, R versus Kilsent, in this case, they stated that a company has been continuously paying dividend. Actually, the company was running at a loss. Continuously running at a loss. They made a profit at a wartime. During World War time, they made a profit. The profit was in the company. And from that profit, they were paying dividend. What they mentioned is, we have been paying dividend. What they have not mentioned is, the dividend payment comes from a wartime profit, not from current year's operation. It is a misrepresentation. When the statement can be made with 2 meanings, they should give the correct meaning to that statement. They should not make a statement with 2 meanings. One case, Smith versus Chadwick. In this case, they say that the turnover is 10 lakh pound sterling. But actually it was their capacity. Working capacity was, installed capacity was 10 lakhs. They can reach up to that level. They were giving a misleading statement. It was held to be a misrepresentation. Another one is if there is subsequent changes that should be notified. They issue prospectus, subsequently there is a change before the person makes a decision to invest, then the company has a duty to advise the other people that these are the changes in between. T.S. Rajagopal Iyer versus South Indian Rubber Works Limited. During the issue of prospectus, there were so many directors. Subsequently, they retired. They came out of the directors board. But this intimation was not given to the shareholders. That persons who received the prospectus, that shareholders, they purchased the share from the company based on the information that these people are the directors. Actually, they were not the directors. They were the directors at the time of issue of prospectus. At the time of filing the application for purchase of shares, they were not the directors. It was held the company should have informed the applicants that these people have retired or these people have resigned from the directorship. That should have been intimated. That was not done. So they have taken a share on a wrong information. They are eligible for rescinding the contract. This is a general rule. But this right to rescind will be lost in some cases where by affirmation. This person knows that there is a misrepresentation, but subsequently he is collecting dividend warrants from the company and crediting his account. Then by his contact it is proved that this person has affirmed the action of the company. Next is delay. He knows the fraud, he knows the misrepresentation, and after 5 years he is coming to the court, then court will say there is undue delay. You cannot do that. Third one is when the winding up started, then this person cannot go for rescinding the contract. This is the third one. Fourth thing is liability under section 26. If the information are not correct, Companies Act section 25 says that directors are liable. They are liable for liable under section 447. Section 34 gives a criminal liability to the director. 35 gives a civil liability, that is compensation. And apart from this, section 26 there is some punishment for the directors in case if there is a misrepresentation. We will see another topic in another lecture.